Welcome back. We're going to talk now about verification to denials. Denials happen to be our favorite part of the no-fault process because that's what everybody hangs their hat on. We need our timely denials. Everything needs a timely
Mhm.
denial. That's the first step. First thing we do in motions and arbitrations. The first question that we get asked in arbitration is, okay, do we have timely denials? Does everyone agree? So how do we get to our timely denial? Well, once we've went through the tolling process, our tolling ends when we receive the verification that we requested. Whatever that information is, the data complete EUO is completed, the day you get the returned forms or the HIPAA compliant forms we requested, the day the statement was taken, if we were requesting statements, if we needed films, the day we got those in the door, the day we got wholesale invoices in. If they're not fraudulent, that's another story for another day. Uh, Partial or unclear responses can require further verification. If we get half of a document or something's illegible, you can send another follow-up. Again, it continues to toll, but you need to stay within the time frames. The 30-day clock will start after the verification's completed. And then our stock, boom, 30 days starts ticking away.
Mhm.
Simple enough. So as soon as we get that verification, that's going to click our dates. It's calendar days, the 30 calendar days. The day one is the next day after you get it. And I say be careful, look, because 30 and 31 days, a lot of times you'll see, let's say January is 31 days. So if we get a final verification in or a bill received on January 1st, then on January 31st, it needs to be denied. But if you get it on, let's say, January 2nd and you deny it on February 2nd, you got to be careful because that month had 31 days. That's going to be a 31st day. So be very careful on those dates and subtract backwards sometimes if you need to. But the 30 days is pretty strict. Just watch the months. February can be tricky, 28 days, sometimes 29 days. So you got to watch that month a little more closely as well. What must be in
February always
the
makes it difficult.
denial? What, Chris?
I said February always makes it difficult.
Yeah, yeah, it does. People start going like
Like, are
this.
we in a leap year? Yeah.
It also could help us at times because the plaintiffs don't catch on untimely denials.
That does happen. You're 100%
Uh-huh.
correct. We just kind of let it go.
No, we just sit there silent. We don't need to make their case.
Right. And we most of the time what's in the denial is good because we're using prescribed forms and the denial has everything that needs to be in there. We haven't really seen too much where the denials are lacking information. Once in a while, again, it needs to be in writing on the forms, signed and dated. We have seen undated denials. We have seen unsigned denials. Those are going to be invalid. We want to attach the relevant proof, the IME, the peer, etc. Cite to the regulations when possible. If there's cooperation clause or failure to provide necessary the NF2, whatever it is, if there's some type of regulation that you can cite to it, it helps to do that. What we do see sometimes are typos, which human error occurs, where the wrong peer-reviewed doctor's name is in there or the wrong date of the IME. I know we see this a lot. How do you guys deal with those situations? We call them de minimis errors, or do we get away with that?
I mean, I feel like our adversary argues that they're material errors, right? Especially when there's multiple IME reports.
Hmm.
But yes, the argument is de minimis, and we see where it goes from there. There's also times where it says it's denied on an IME, and like I said, there could be multiple IME reports, and they argue, well, how is the recipient supposed to know which IME they're relying upon? That's also, it is important to be detailed for sure. And I always say with the denials, because fee schedule is always an issue that may be raised, and I see it commonly done, always check off that box. I don't know, is it box 16 or whatever, where it's a fee schedule defense? Always check it off.
Let's check it off because we just don't know at that time. Oftentimes, going through the fee schedules, we have had situations where we wind up on an IME and, whatever the situation may be, but then we do have a valid fee schedule defense, which doesn't
Mhm.
need to be in a timely denial, which we'll get to in a minute.
And we also want to preserve it just to give us time to confer with a coder to see whether or not
Mm.
we do have a valid fee schedule defense. Preserve it rather than losing it. Mike, what you were saying about being, we're adhering to the four corners of the denial. So if it's listed on the denial, that's what we have to stick to. Oftentimes, if there is a de minimis error or typo, we like to accompany that with an affidavit,
Right.
a affidavit from
Right.
the examiner,
Yep.
and addressing these things head on. Sometimes, everybody's human, and sometimes there is a little bit of an error, whether that's an amount or a date, and not to cure or try to rectify what's in the denial, but an affidavit, a signed affidavit from an examiner helps in those scenarios.
Absolutely.
Right, to just address the error that was made. And even sometimes just flat out say, there's an error in the denial. It's actually this, and I
Right.
have knowledge of that, which is sometimes arbitrators and judges appreciate those types of things.
Yeah, what happens I mean, if we miss a date, if a date gets wrong in the denial of a peer review or an IME date, but we do attach or should be attached the relevant proofs, so the reports should be attached. So our position as well, the dates were, but we attach the peer review so they clearly were notified of what it was.
Yeah,
Right.
absolutely. That is it's a perfect way to
Yeah,
again, you're not rectifying or fixing the denial, but it's just a good argument to be made that the person
right.
who received it obviously knew the basis of the denial. So yeah.
Absolutely. The legal formatting requirements, again, we're doing these on the prescribed claim form, so it's generally not an issue. You need to include everything, all the boxes, the insurer's name, the policy number, the claim number, the date of the loss, the dates of service, and the bills. Some carriers have bill numbers that correspond to each of these bills that go on the denial. Identifying the date the verification received, that box, date verification received, that's going to be matched against your 30 days at the end when you date and sign that denial. Mailing, whoever's doing the mailing, please follow the company's business practices for mailing to the letter exactly so that later when we go, it could be a year, it could be 2 years, it could be up to 6 years later. That's the statute of limitations. We want to be able to go back and look at the notes and say, oh, the mailing procedures were followed exactly in this particular situation to establish those business practices. And try and CC all the necessary parties that you need to CC on those denials at the end. That becomes important as well.
Especially when general denials go out. If you have a list of providers, we want to make sure the provider that we're dealing with is listed as being notified or CC'd on that general denial.
Mm-hmm.
Those general denials have to go out to every provider that you're aware of at that juncture.
Yep.
Which is
General.
key. That's the key word, aware of. So let's just say later on the claimant has a surgery and you weren't aware of that surgeon because it usually happens later on in a claim. It's okay, but always CC all the available known providers. That's a great tip. Yes.
And another
Yeah.
thing really quickly, Mike, before you switch slides,
Yep.
is keep in mind what we spoke about in the last section with consistency of addresses, consistency of all relevant information. And that also includes whether, some carriers like to have, like Mike said, their own bill number, their own identifying number on certain documents.
Mm-hmm.
Sometimes our applicants and plaintiffs will argue, what is this number? It means nothing to our case. We want those, if those are being listed either on a denial or on a verification request, that those numbers, those specific bill numbers are referenced on each of those documents and they remain consistent. So, I think the main overarching themes here is adhering to the timelines, but also being very consistent about the information that you're listing on these prescribed forms.
And you guys, we mentioned general denials. I mean, I think we know what a general denial is, but just in case, what general denial is when there's a policy violation of some kind, like not necessarily policy violation, but it could be an IME cutoff where no more benefits are going to be given. A general denial goes out. An EUO no-show, general denial based upon that goes out. So we include those general denials in our verification and in our motions to show when the actual cutoff was done. It's not necessarily required in a motion. If we have a timely denial in that one specific bill, we always include our general denials. What happens if there's an untimely denial? When there's an untimely denial, we go like this. There's nothing we can really do about it. We're out of the park. Everybody knows that we are. That's the first thing that gets looked at. And in our motions, it's always denials are timely. We have to prove that to get to the next step. We waive most defenses. Fraudulent or staged events, the courts have come back and said, well, if it's a fraudulent event, if it's a staged accident, then it's not really an accident. There's not going to be any coverage. You don't need a timely denial for that. We're not going to have you adhere to those practices, to the timeliness if there's fraud involved. And the court also said if there's improper fee scheduling and we have a late denial, they're going to say, well, it still needs to be billed at the proper rate, and we're not going to waive that defense either.
Yes.
And we get precluded in arbitration litigation again with the late denials. We're out of the box. And once the claims become overdue, let's not forget interest is ticking. With a late denial, once they start those claims, that's when the attorney's fees will start kicking in as well. How do we use these in arbitration litigation? Well, at the end of the day, that's what it comes down to. How do we use these in arbitration litigation? We, of course, as attorneys want them perfect. They're not always perfect, but the denials, we want the verification dates matching. The date final verification received, we want this matching. We want that to be within 30 days. The supporting documents, when we use them in litigation, need to be admissible. So for mailing, it's usually an affidavit following the business practices of the mailing specifically. Timely denials support defenses, late denials lose defenses. We already spoke about that. So the time frames of these denials, it really boils down to whether or not we're going to be able to proceed to get to the actual merit of the case or the reason for the denial through that timeliness.
Also remember and keep in mind, as Christina pointed out, you want to check off the box of fee schedule for more than one reason. If your denial is untimely, you still are well within your right to preserve and prevail if the coder is accurate on the fee schedule defense. Just because we have an untimely denial, we issued the denial beyond the 30 days. According to Saddlebrook, it's a case called Saddlebrook Surgery Center versus Allstate Insurance Company. And that's a case that's helpful to us in those instances where we are able to address our fee schedule defense and still possibly prevail on that. You don't lose that defense just because your denial was untimely. We see that a lot, actually. Not too often. Not too often. The adjusters are pretty good about getting them out within 30 days.
We see this a lot where, let's say it's a denial based upon a peer review and, the plaintiff has their documents in a row and the arbitrator or the judge is going to favor the plaintiff's side. And they say, well, we're finding this to be medically necessary. We still have the fee schedule issue that we can address and at least get that number reduced to the proper rate.
Right.
Absolutely. And as our other Christina pointed out, make sure our addresses are accurate and are depicted as the same ones on the bill. That is super important.
Mm-hmm.
Can't stress it enough.
Yeah, we could say that over and over and over again.
Yeah. I think we covered pretty much what we need to cover on this topic for now. If there's anything else that anybody wants to see or is interested in seeing or expanding upon here, or if you think we didn't get something right, let us know that too. We're not perfect, but
I welcome that.
Yeah,
although I think we are slightly perfect. But
you guys have anything you want to add as far as this process goes to help people kind of understand it a little bit better? I think we covered it pretty decent.
No, I think we did a good job. I mean, document as much as possible, document everything, keep everything consistent, keep an eye on the timelines. And if you have any questions, I think we're here to help.
All right.
All right.
Very good. Enjoy the rest of your day. Thank you very much for joining us. And we'll see you guys soon.
Until next time.
Till next time. Enjoy the denial process. It's so much fun. Bye.